Speaker.
I call the Honourable Phil Goff.
Mr. Speaker, that speech from Tim McIndoe perhaps reflects the weakness of the changes proposed by this government to the role of senior counsel, in that it lacked any rationality, it lacked any hard facts or evidence, and relied solely on emotionalism. He's absolutely wrong, of course, that the Labor Party rejects Westminster traditions. We're proud of our Westminster traditions, but we believe that the laws of this country, Mr. Speaker, should reflect the 21st century and not the 16th century. You know, there are three things that Labor is opposed to in this bill, and I want to go through each of them and invite the next National Speaker perhaps to bring some facts to the argument instead of the nonsense that we've heard. Because this bill is about privilege and snobbery. It's not about Westminster traditions. It is about exclusivity. This national government that's always attacking trade unions doesn't attack one of the strongest trade unions in this country, which is the Bar Association and the Law Society. Because there's so many lawyers on that side and they're looking after their mates, they bend over backwards to protect the trade restrictive practices of that profession. That's what the member's doing. It's okay if you're Federated Farmers or the Law Society. Those are good trade unions and will protect the privileges of those who are the best off. It's only the people, the unions, that protect the poor in this country that they attack. Mr. Speaker, we're against the change in title because the title they want to go back to is anachronistic. We're against having an exclusive pool of people who can become senior counsel because that is a trade restrictive practice, and we're against their reversion to a system of selection for senior counsel that is shrouded in secrecy and is prone to the old boy network looking after itself. And I want to elaborate on each of those 3 points, Mr. Speaker. The changes that we made in relation to the title back in 2006 were in line with the trend of every other Commonwealth country that has a common law system. The Australians don't talk about Queen's Counsel, they talk about Senior Counsel. They're proud of their Westminster tradition, but they want a title that reflects what we're actually talking about. The term Queen's Counsel was quite appropriate in the 16th and 17th century, and that's perhaps where Tim McIndoe would have felt more comfortable with life, when people respected their betters and the aristocracy. In those days, Queen's Counsel were counsel to the monarch of the day, and it was quite appropriate to call them that. Today, most Queen's Counsel, most of the time, are not representing the Crown. They're representing business, they're representing private interest sector, and occasionally they might be acting on the instruction of the Solicitor General or a Crown Solicitor. But that is the exception rather than the practice. So if we want to have a title that is accurate about the role, we will call them Senior Counsel and not Queen's Counsel. What is it so wrong about what the Canadians or the Australians are doing that is condemned by the National Party and they want to go back to the term Queen's Counsel? It is purely about status. It is purely about snobbery. There is no other rational justification, and from the Minister and the first Speaker of the National Party, we've not even had an attempt to give a rational explanation as to why they are making that change. You know, when the Select Committee was doing the hearings on it, they were attracted to the comments by a person that's very respected in the legal profession, Jack Hodder, who himself is a senior counsel. And actually, Jack Hodder said, we should really wonder whether there should be such a rank as Queen's Counsel. What other profession, he challenged the Select Committee across the country, lawyers, apart from lawyers, you know, people like accountants or engineers, have a title, a ranking that they give to a select group within that enables them to charge a lot more for their services. Now, I don't go as far as Jack Hodder. I think that it is appropriate that you should recognise excellence within the profession. But I want to say this, Mr Speaker, if you're going to recognise through the use of a title excellence in the profession, then it should be done on merit across the profession, not restricted to a tiny minority group of barristers sole, but across the whole profession. And you know, one of the contradictions of this legislation is that the government semi-acknowledges that. It first of all places the restriction that it should only be barristers sole, and then makes a provision, but excellence can be reflected in occasionally from across the majority of the profession. Now, if the national government really believes that the argument for restricting it to barristers sole is that only barristers sole can be independent, then that would have been a total rule laid down. But they've acknowledged the weakness of their own argument by saying that the Governor-General can appoint from other areas of the profession, Mr Speaker. The fact is, in every other regime, including in the home country of the Westminster system itself, England, they allow appointments from across the profession. England did it in 1995. And I want to say to Tim McIndoe or any other person in the National Party that addresses this bill, bring up some evidence that extending the appointments to across the profession has caused a breach of independence or a lowering of standards. Not one instance has been given to this House, not one instance was given to the Select Committee. They've done it in Australia, they've done it in Canada, and in the home of the Westminster system in England, they've been doing it for 18 years, and they've been doing it without any problem at all. And I believe this restriction is because the value of the title is that you can double your fees. At least double your fees. $900 an hour, we heard from the Minister of Justice, isn't unreasonable. Well, it might not be unreasonable if you're receiving it, but by God, it's unreasonable if you're paying it. And I believe the only reason they have done this is to narrow the group of people who can carry that rank and to increase the payments that a small and select group can take. And that is a bad ground for any legislation of that nature, Mr Speaker. Mr Speaker, there is every reason to maintain the ability to draw on excellence within the profession from across the profession. There is no valid reason that I have heard from any government member as to why the restriction imposed in 1915 should be put back in place when there is no evidence that that restriction is needed. Every lawyer has an oath, takes an oath, and is obliged under the Lawyers and Conveyancers Act to be independent in representing the interests of their client and to be independent in terms of the duties that they owe to the court. The argument of independence for restricting it to barristers sole simply doesn't exist. Mr Speaker, I want to come to the third change that is a very negative change being proposed by the government, and that is to go back to an old system of appointment to the rank of Queen's Counsel that is based on who you know and the old boys network looking after themselves. In 2006, we made the change to replace opaqueness with a transparent system. That we had a panel where the Solicitor General was on the panel, representatives of the Bar Association and the Law Society were on the panel, and everything was clean and above board. Why was it necessary to change that? I have heard not one word from the Minister, not one word from the national government that justifies going back to a system that enables the government to look after its own in conjunction with a few select people within the judicial system. It is in the interests of transparency and democracy in this country that appointment to a rank like senior counsel be done in an open and clear and transparent way. So, Mr Speaker, to wind up as you're suggesting I should, There are three reasons that we're opposed to this. The title you're going back to, the title the national government's going back to, is anachronistic. The system of appointing from a very narrow group doesn't recognise excellence across the system, and having a system of appointment that is not clear, is not open and not transparent, is open to abuse. This is a bad bill and Labor will oppose it, and it will reverse it when it gets the chance.
I call the honourable member
Mr.
Julie
Speaker,
Ann.
Mr. Speaker.